Thank you.
Thank you, sir. It's a pleasure to serve under your chairship, and I want to thank my honourable friend from Rushcliffe for bringing forward this really important debate. Sir Christopher, currently there is no general duty on universities to take reasonable steps to prevent foreseeable harm to adult students. With much of the University of Wolverhampton, in my constituency of Wolverhampton West, I've been working closely with the Director of Student Life and designated safeguarding lead at this university to address this issue. Campaigners are not asking for strict liability or for universities to take the form of a parent, but what they are asking for is something fair and simple. Where a university becomes aware of a foreseeable risk of serious harm to one of their students, it should take reasonable steps to reduce and prevent that risk. That duty of care is applied in workplaces and colleges, and higher education should not be an exception. When I raised this matter in the House last May, I did get a response from the Minister for Skills, who said that a duty of care may arise in certain circumstances. Such circumstances would be a matter for the courts to decide based on the facts and context of the case being considered, and will be dependent on the application by a court of accepted common law principles. So, Christopher, I became an MP to be a legislator, and as MPs, we cannot absolve our duty as legislators by saying that it is for the courts to clarify the uncertainties that exist with the law. It is for us not only to clarify the law, but to make it stronger and make it sensible. As a personal injury and clinical negligence solicitor for more than 30 years before I became an MP, I do find it quite shocking, in fact, that the common law does not impose a duty of care on universities to exercise reasonable care and skill for the well-being, health and safety of their students when they are teaching their students or providing education-related services, and also to take reasonable steps to prevent that injury, including psychiatric injury, when such a statutory duty does exist in prisons, hospitals, primary and secondary schools and colleges of further education. This duty of care in negligence also exists in a variety of other situations. For example, doctor to patient, solicitor to client, manufacturer to consumer, and one road user to another. There are very well-established principles of negligence which state that where a duty of care exists and that duty is breached, resulting in injury and or financial loss which was reasonably foreseeable, then negligence has occurred. I bring the tragic case of Abrahart again. In Natasha's case, there was reasonable foreseeability of Natasha's health suffering and having a psychiatric disorder, but it was held that the university was not negligent because the university did not owe Natasha a relevant duty of care. In October 2017, university staff became aware that Natasha was struggling and was experiencing anxiety and panic attacks in response to oral assessments, and in February 2018, a university employee received an email from Natasha saying, "I've been having suicidal thoughts and to a certain degree attempted it." And at that time, Natasha had been diagnosed with chronic social anxiety disorder. But the university continued to mark Natasha down on her assessments, when the court confirmed that there were other ways of eliciting information from the student rather than having these oral assessments. The court therefore concluded that had there been a duty of care in existence, there would have been a breach of that duty, and the university would consequently have been negligent for their actions. Natasha's claim succeeded only under the Equality Act 2010 on the grounds of disability discrimination because the university failed to make reasonable adjustments based on Natasha's disability. But there are other reasons, Sir Christopher, to do with legal costs, to do with time limits, as to why, in order to achieve justice, it should be possible to pursue a claim in negligence where a university has been negligent. Yes, of course.
Thank you for giving way. On that point, I think it's not adequate for us to have to rely on a determination that someone's suffering from a disability because of the mental health issues, because we know that with some cases there will be a history and there will be engagement and there will be a diagnosis of a disorder. But in many other cases it could be something that the student has suddenly feels themselves in this situation, and we know that there's not always that long pathway up to suicide. It could be something that is triggered by a particular event. So I just share my concern that relying on the Equalities Act is not adequate in the cases of these students.
The Honourable Member makes a really very valid and good point. There are going to be cases where a student is vulnerable and where action needs to be taken, but that student may not have been diagnosed with a disability. And it just does not feel fair that the university in those circumstances should not take any steps to deal with the student's vulnerability. So I do agree with what the Honourable Member is saying. It cannot be right, Sir Christopher, that currently there is no duty on universities to take those reasonable steps to protect the welfare of their students and to take reasonable steps to prevent them from suffering harm when it is reasonably foreseeable that a failure to act will result in harm. Establishing such a statutory duty of care will ensure that the law in this country is brought into line with the position in other common law countries, such as the United States and Australia, but more importantly, give clarity to judges to ensure that justice is achieved, there is access to justice, and universities are also given clarity about their responsibilities so that they can take the appropriate action to prevent the loss of young lives in their institutions. A statutory duty of care for universities would define expectations, embed accountability, and promote prevention. It would not burden universities unnecessarily, but align them with the responsibility already expected in other sectors. So, Christopher, this is about fairness, clarity, and about saving lives. Parliament must act to close this duty gap. Students and their families deserve better. Universities need certainty, and the courts need clarity. As parliamentarians, please let this happen.